idea that a judgment that is void ab initio never existed. We can't see it. It doesn't exist. It doesn't exist.
Yeah,
so doesn't that lead to the conclusion that was drawn by all these courts of appeals?
No, and here's why. In addition to it's conflating the grounds for relief in 60B, fraud by the opposing party, and you've already paid the judgment, you've already paid it. How can you make me pay it twice? And the example we give in the brief, and I think it's quite instructive, is the area of preclusion. This court has already said that courts can give effect to void judgments, even concededly void, because if a party unsuccessfully challenges subject matter jurisdiction, they're barred by res judicata and collateral estoppel. And if it's concededly, on its face, it's issued by the Court of Clowns, you have to give effect to the judgment based on res judicata. Now, I will say, if you have a Court of Clowns example, you could probably get rid of that under the independent action for gross injustice.
Well, then what should we say about void ab initio, in our opinion? Well, it doesn't really erase it from the annals of history. It has, that's an overstatement.
It's not an overstatement to describe fraud on the court or fraud by the other party or void ab initio. That's the grounds when you get into court under Rule 60. That's the procedure where you get relief from that judgment. The whole concept of Rule 60C assumes that there are quite offensive judgments and it's giving you relief, but there's either a 1-year time limit, a reasonable time limit, or no time limit, and this void judgment falls in the reasonable time limit.
Well, if